Supreme Court Justice Ruth Bader Ginsburg died on September 18, 2020, and with that, there was a seat open on the United States Supreme Court. The Supreme Court makes decisions on big issues that impact people's everyday lives, from abortion to guns to healthcare and more. Their rulings depend on the opinions of each justice sitting on the court. This video is going to explain the Supreme Court, what it does, how justices are confirmed, and how the court looks today. The federal government is composed of three branches: the judicial branch, the executive branch, and the legislative branch, made up of the Senate and the House of Representatives. Simply put, the legislative branch writes the laws, the executive branch carries out and enforces laws, and the judicial branch determines the meaning of those laws, as well as the U.S. Constitution, and how they apply to the disputes before the courts. To illustrate this, let's look at a woman's right to vote in the United States. In 1875, there was a Supreme Court case, Minor v. Happersett. Virginia Minor attempted to register to vote in Missouri, but was refused because she was a woman. She argued that the 14th Amendment made all citizens equal under the law, and citizenship includes the right to vote. The Supreme Court at that time decided that the constitutionally protected privileges of citizenship do not include the right to vote. Instead, women across the entire nation received the right to vote through the constitutional amendment process, beginning in the legislative branch. It was not until 40 years later, on August 26, 1920, that the 19th Amendment was passed, plainly saying that the right of citizens of the United States to vote shall not be denied on account of sex. So there are two avenues in the U.S. government to create change. Legislators can pass laws through the legislative branch and propose constitutional amendments, or Supreme Court justices can decide the meaning of the Constitution and existing federal laws. In this case, the Supreme Court decided that the Constitution at that time did not protect a woman's right to vote in the U.S., and therefore, it was incumbent on the legislative branch to propose a new constitutional amendment to certify that right. So, how are new justices added to the Supreme Court? Article 2, Section 2 of the U.S. Constitution says, "The President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court." Simply put, judges are nominated by the President of the United States and confirmed by the Senate. The Supreme Court is composed of 9 justices. To understand where we are today, let's start here in 2016. This was the court: 5 justices nominated by Republican presidents, and 4 justices nominated by Democratic presidents. Antonin Scalia, one of the most conservative judges on the court, died, leaving an empty seat on the Supreme Court. On average, it takes 69 days, a little over 2 months, to go from nomination to confirmation. Scalia's seat opened on February 13th. Merrick Garland was nominated 1 month later, on March 16th.
Today I am nominating Chief Judge Merrick Brian Garland to join the Supreme Court.
So let's see what happened next. This is the Supreme Court confirmation process. After nomination, the first step is putting the nominee on the Senate calendar for consideration by the Senate Judiciary Committee. The Senate was controlled by a 52-48 Republican majority. The Senate Majority Leader, Mitch McConnell, was in control of the calendar in combination with the Senate Judiciary Committee Chairman, Chuck Grassley. Neither McConnell nor Grassley acted on the nomination, refusing to even consider his nomination for 2 reasons. One, it was an election year, and they said the American people should have a voice in who is added to the court.
The next justice could fundamentally alter the direction of the Supreme Court and have a profound impact on our country. So, of course, the American people should have a say in the court's direction.
Second, the Senate majority and presidency were held by opposing political parties, and McConnell said his inaction was an exercise of checks and balances.
It is a president's constitutional right to nominate a Supreme Court justice and it is the Senate's constitutional right to act as a check on a president and withhold its consent.
Whether or not you agree with his reasoning, the Senate waited out Garland's nomination over 9 months, until the end of Obama's administration. After taking power, President Trump nominated Neil Gorsuch to the seat.
I have always felt that after the defense of our nation, the most important decision a president of the United States can make is the appointment of a Supreme Court justice.
Now that the Senate majority and the presidency were both Republican-controlled, the process moved forward with Neil Gorsuch. First step, he was added to the calendar for consideration. Then the nominee moved to the Senate Judiciary Committee for investigation and public hearings.
Had you ever met President Trump personally?
Not until my interview.
In that interview, did he ever ask you to overrule Roe v. Wade?
No, Senator.
What would he have done if he'd asked?
Senator, I would have walked out the door. It's not what judges do.
Concluding with a committee vote on what recommendation to make to the full Senate. A committee considering a nomination has 4 options. It can report the nomination favorably, unfavorably, without recommendation, or it can choose to take no action at all. With a majority in the full Senate, Republicans had a proportional majority on the Senate Judiciary Committee, with 11 Republicans and 9 Democratic senators. There was a complete party line vote, meaning every Democratic senator voted against him, and every Republican senator voted in his support. So Neil Gorsuch was reported favorably to the full Senate. Next, the nomination was sent to the full Senate for debate, where senators take the floor to remark on a nominee's professional qualifications, character, judicial philosophy, and views on constitutional issues, and share their reasoning for voting in favor of or against a nominee's confirmation.
I would still oppose the confirmation of Neil Gorsuch. My objection is based on Judge Gorsuch's record, which I have reviewed in detail.
Strongly support Neil Gorsuch for the United States Supreme Court. First, there's no question that Judge Gorsuch is qualified for this job.
Senate rules at the time placed no limits on how long floor consideration of a nomination may last. There are 2 ways the Senate can end debate: unanimous consent or a motion to end debate called cloture. Unanimous consent is just what it sounds like. All 100 senators must agree on the rules to proceed, and this often includes a time limit for debate and the date the Senate will vote on the nomination. Without unanimous consent and a set time limit, senators can filibuster, which is the use of any delaying tactic, including extended debate, to postpone or prevent a final vote from happening. To override a filibuster, supporters of the nomination have the second option, calling a vote to invoke cloture, which limits further debate to just 30 hours. At the time, this required a supermajority of 60 out of 100 senators to proceed. This number was set because the majority and minority parties are supposed to work together to get things passed. The filibuster gives the Senate minority party some negotiating power in the nomination process. In this case, the majority leader could not get unanimous consent and called a vote to invoke cloture. With 55 votes, including 4 Democrats, Republicans lost, unable to achieve the 60-vote threshold, and opted for the nuclear option, voting to alter the Senate rules so that only 51 votes are needed to invoke cloture for Supreme Court justice nominations. This was a big deal, effectively eliminating the filibuster for Supreme Court justices and crippling minority party influence in the Supreme Court appointment process going forward. However, this is not the first time Senate rules have been changed to reduce the power of the minority party. In 2013, the Democratic Party majority changed the cloture rules to end debate for all other judicial and executive appointments from a 60-vote requirement to 51 votes, except for the Supreme Court.
In 2013, then Majority Leader Harry Reid changed the Senate rules to eliminate the 60-vote threshold on most judicial and executive branch nominees. Those in my party, including me, were enraged. Rightly so. We warned that the Democrats would not be in control of the Senate or the White House forever, and that they would come to regret their actions. We were right. It is imperative that we have a functioning Senate where the rights of the minority are protected regardless of which party is in power at the time. I find myself torn between protecting the traditions and practices of the Senate and the importance of having a full complement of justices on the U.S. Supreme Court. I'm left with no choice. I will vote to change the rules and allow Judge Gorsuch to be confirmed by a simple majority. I will do so with great reluctance.
This change passed with a party line vote, 52 to 48, changing the requirement to end debate from 60 to 51 votes. They voted on cloture once again. The same 55 senators voted to end debate, and this time, the motion passed. Then came the final vote to confirm Neil Gorsuch, which passed with 54 votes, including 3 Democratic senators.
On this vote, the ayes are 54, the nays are 45. The nomination of Neil M. Gorsuch of Colorado to be an Associate Justice of the Supreme Court of the United States is confirmed.
Lastly was his swearing-in ceremony, making Neil Gorsuch an official justice of the Supreme Court.
As Associate Justice of the Supreme Court of the United States.
As Associate Justice of the Supreme Court of the United States.
Under the Constitution and laws of the United States.
Under the Constitution and laws of the United States.
So help me God.
So help me God.
Congratulations.
So that is the Supreme Court nomination process. Notably, the Senate rules were changed such that the Senate minority party has no meaningful way to filibuster or prevent Senate proceedings on a Supreme Court nomination moving forward. So Neil Gorsuch got Scalia's seat, a conservative justice replacing a conservative justice. Who joined the Supreme Court after that is where things got interesting. Justice Anthony Kennedy retired in 2018, and nominee Brett Kavanaugh went through the same Supreme Court nomination process and was confirmed to the Supreme Court.
So help me God.
So help me God.
On its face, this may seem like just another Republican nominee replacing a Republican nominee. However, not all Republican-nominated justices are ideologically equal. To understand this, we have to understand the ideological framework of the court. Justices are supposed to be apolitical arbiters of the law. Their own personal political views should not matter. Hence, conservative versus liberal in the court system is different than Republican versus Democrat in politics, though their general perspectives are often aligned. Liberal justices are described as believing in a living constitution, applying the words in the Constitution to modern society and the issues of today. Conservative justices are called textualists, believing that judges should apply the Constitution as written and intended by the people who wrote it. Generally, Republicans set out to nominate conservative judges, and Democrats set out to nominate liberal judges. However, these philosophies can be difficult to predict and unique to each individual judge. Let's take a look at the Supreme Court of 1973. This is how judges ranked based on their Supreme Court decisions. As you can see, Republican-nominated judges range from the conservative side of the spectrum to the liberal side. In 1973, they decided the case Roe v. Wade that established a woman's legal right to an abortion in the United States. The decision came to a 7-2 vote, comprising 5 Republican-nominated justices and 2 Democratic-nominated justices. Of the just 3 Democratic-nominated justices on the court, 1 joined the dissent. As you can see from this case, the party that nominates a justice doesn't always get what they want. In fact, political parties struggle to predict how their Supreme Court nominees will vote once confirmed. And justices often disappoint their nominating political party by voting against policy objectives on big issue cases. However, political parties aside, the ideological center of the court does matter a lot for how big issue cases are decided. The true impact of each justice can be seen in the 2015 Obergefell v. Hodges case, which legalized gay marriage in the United States. The decision came to a 5-4 vote, comprising all 4 liberal justices and the most moderate Republican-nominated Justice, Anthony Kennedy. Many highly contentious decisions on the Supreme Court have been decided by 5-4 votes, and senators know that any new appointee can have a decisive impact on how big issue cases will be decided going forward. The nomination of Brett Kavanaugh to replace moderate Justice Kennedy was considered hugely impactful by some senators, potentially shifting the court's ideological balance in a more conservative direction. Of course, this could be seen as a good thing or a bad thing depending on your personal preferences, and his judicial philosophy will come into focus as more decisions play out. Kavanaugh has already made a decisive impact on a number of big 5-4 cases, voting with the other conservative justices. However, it's worth noting that both Kavanaugh and Gorsuch have sided with Democratic-nominated justices on several notable cases, to the dismay of Republicans. And that brings us to today. On September 18th, 2020, Justice Ruth Bader Ginsburg died, leaving an empty seat to be filled. President Trump nominated Amy Coney Barrett on September 26th, and she was confirmed on October 26th. A presumably conservative justice replacing a liberal justice, once again shifting the balance of the court in the conservative direction. Her confirmation to the court creates a 6-3 conservative majority, so big issue cases have a higher likelihood of being decided in the conservative direction. There are a couple controversial subjects that came up during her nomination process. 1, how quickly Barrett's confirmation went through. 2, what the minority party could do to stop or influence the process. 3, who should have filled the seat, the current president or the next president. First off, Barrett's process from nomination to confirmation was just 30 days. Though this is faster than average, it is not unheard of. In 1981, Justice Sandra Day O'Connor moved from nomination to confirmation in 33 days. And in 1975, Justice John Paul Stevens was confirmed in just 19 days. So while many complained the process was rushed, Amy Coney Barrett's confirmation moved through all the necessary steps in a not unheard of timeline. Second, as mentioned before, there is effectively nothing the minority party can do to delay or prevent a nominee from moving forward. Starting from the confirmation of Neil Gorsuch, every significant vote during the Supreme Court confirmation process requires just a simple majority in the Senate to move forward. The minority party in this case was the Democratic Party, and they used 2 symbolic but ineffectual processes to show their objection to the nomination. First, Democrats boycotted her Senate Judiciary Committee vote.
As you know, our Democratic colleagues informed the committee last night that they will not participate in the hearing. That was their choice. It will be my choice to vote the nominee out of committee. We're not going to allow them to take over the committee. They made a choice not to participate.
Because only Republicans showed up to vote, Amy Coney Barrett received a 12-0 vote to be reported favorably to the full Senate. Next, in the full Senate, Democrats staged a symbolic digital filibuster, including videos and rallies. This did not have any effect to actually delay the vote. The nomination moved forward after Republicans called a successful motion for cloture. Third, the biggest point of controversy was whether President Trump should fill the vacancy just 2 months before a presidential election, or leave the vacancy to be filled by the next president. In 2016, Republicans had refused to take action on Obama's nominee, Merrick Garland, with one of their core reasons being that it was an election year.
This will stand the test of the time. This is the last year of a lame duck president, and if Ted Cruz or Donald Trump get to be president, they've all asked us not to confirm or take up a selection by President Obama. So if a vacancy occurs in their last year of their first term, guess what? You will use their words against them. I want you to use my words against me. If there's a Republican president in 2016 and a vacancy occurs in the last year of the first term, you can say, Lindsey Graham said, let's let the next president, whoever it might be, make that nomination, and you could use my words against me, and you'd be absolutely right.
On the other hand, Democrats had argued that the nomination should be filled by President Obama because it was still his term in office.
Ladies and gentlemen, the work of the people is to evaluate this nominee. It's not to say, I have made the decision I will not give this president an appointment when 14 other presidents have had the ability to make the appointment in their final year. That's not the way this body should function.
Both sides flipped their opinion for the 2020 nomination of Amy Coney Barrett. Republicans now wanted to fill the seat despite it being an election year.
Lots at stake in this election, but today I want to celebrate. I want to celebrate the fact that Judge Amy Barrett will be reported out of this committee unanimously, that to all the young women out there like Amy Barrett, this is a big day for you.
And Democrats vehemently opposed the nomination as unjust.
This hearing is not normal. It is a sham. It is a rush to put in a justice. The last time that we had a vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election.
Both parties flipped their position based on the new circumstances. Though this was viewed as hypocritical by pundits on both sides of the aisle, politicians flipping their view isn't a legal matter. The fact is, under the current laws, it is in the president's authority to nominate a Supreme Court justice, and it is in the Senate's authority to confirm that justice. How they use or arguably misuse that authority is up to them. In conclusion, here are some final takeaways from this video. First, if you want to impact the future of the Supreme Court, make sure your political party holds the presidency and the Senate majority for complete control over the Supreme Court nomination process. Second, political parties cannot control and are bad at predicting how justices will decide cases once on the court. Lastly, however, many of the biggest, most consequential cases, such as those concerning abortion, guns, and healthcare, are decided on ideological lines in close 5-4 votes. And the judicial philosophy of each justice affects the liberal-conservative balance of the court. Looking forward, the three oldest justices, Breyer, Alito, and Thomas, will be over 74 in the next 4 years, and the average justice retires around the age of 74 years old. Breyer is considered a liberal justice, while Alito and Thomas are considered conservatives. Over the next 8 years, the court has the potential to look like this if the three oldest justices retire. Assuming a Democratic president wins in 2020 and 2024, the court could end up with a 5-4 Democratic-nominated majority. If a Republican president wins the 2024 election and no justice had retired before that, the court could end up with a 7-2 Republican-nominated majority. Thank you so much for watching. I hope you learned a little bit about the Supreme Court. And if you like this video, please like and subscribe below.